Do renters need estate plans? That is the question I'm answering for you today. My name is Amanda Rocha. I am an estate planning and probate attorney in California, and this is a question I often get increasingly from millennials for various reasons, which I'm sure you could figure out. So before I get into that, I want to give you my contact information. You can find me on my website at www.amandarocalaw.com. There you can schedule an appointment directly on my calendar to speak with me about what kind of documents you might need to protect yourself. You can follow along on my social media, or you can comment below if you have any questions, comments, or suggestions as to what I should talk about next. So let's get into it. Renters. I've had people call me a lot asking what is it that they need, and particularly if they don't own a home. A lot of people these days are serial renters, and like I said, that's due to a lot of different reasons. Sometimes it's preference, sometimes it's just they can't afford it, whatever it is, it doesn't matter. The reason that they call me is because they either listen to my podcast or see me on social media, follow along on TikTok or whatever it is, and they've seen me talk about how everybody needs certain documents. They always feel precluded because the word estate seems like a grand estate where you have tons of money and tons of assets, but that does not necessarily mean anything. You can have an estate with just your personal belongings, and that's it. And that's the same word that we use when somebody has, 15 houses and 100 cars. So really, what is it that a renter would need is going to depend on that person's specific assets, regardless of whether they own a home. So let's just talk about things that I think everybody should have. First of all, as I've said before, and I'll say it again, and I'll keep saying it until I can't say things anymore, when you turn 18, you should have a will. It doesn't have to be a long form will that has a ton of information. It doesn't have to be complicated. You don't have to own anything of substantial value. But what a will will do is discuss where your property goes when you pass away. So if you don't want it to go to who the court assigns, which would be your next of kin, then you have to put that in a will. If you want certain items to go to certain people, you need to put that in your will. A will, though, will not avoid probate. So if you have assets that add up to more than $184,500, then those assets may trigger a probate case regardless of whether you own a house. So that is why it's important to reach out to an estate planning attorney like me. I'm in California. I can talk to you about your estate wherever you live in California, and we can discuss what other strategies we might use to protect some of those assets. A will is submitted to the probate court, and the judge reviews it, and as long as the will is completed correctly, then it will be followed. The next thing that I think everybody should have over the age of 18 is an advanced healthcare directive. I've talked about this before as well. There's nothing new in this video if you've watched or listened to me talk before, but it's good to have it all in one spot. An advanced healthcare directive talks about you, yourself, your body, when you are incapacitated. So if you cannot speak for yourself anymore, whether that's because you are in a coma or you aren't mentally capable of making decisions on your own behalf, this document steps in, and first of all, it talks about what you want done in a situation, a medical situation, when you can't say so, if you have any preferences. And secondly, it names a person, an agent, to be your healthcare power of attorney who can make sure that that document is followed and also make any decisions above and beyond what the document includes with regard to your healthcare only. This document isn't going to be an immediate document if you don't want it to be. That means that whoever you name in there isn't going to immediately have a power of attorney sign and allow them to go around and do whatever they want. We can make it a springing power, which means you need to have 1, 2, or a team of doctors say that you are incapacitated. The beauty of this document is that as soon as you're incapacitated, it kicks in without any court involvement, and as soon as you've regained capacity, it's dormant again until the next time it's needed, if it ever is. Along those same lines, there is a durable power of attorney, which is for everything outside of healthcare. Basically, all the same rules apply. as to what I just said. It kicks in when you need it to, and it goes away when you need it to. No court involvement. And if you have children who are minors, I recommend that you have a guardianship declaration discussing who you would want as their guardians in a temporary and permanent capacity, because who a court will choose or a judge is not necessarily who you will. And it's nice to have that information in there, especially if there is a blended family situation going on and you have reasons as to why you would not want your children going in certain places. That can all be put in that document. There are a few other random ancillary documents that we could include depending on what your estate looks like. So if you're curious to know what I would suggest for you, you can go to my website, www.amandarocalaw.com, go to contact us, and schedule a time for strategy session on my calendar. You can drop a comment below if this platform allows you to do that, or follow along on my social media. You can send me a DM that way. I'm at Amanda Rocha Law. Thank you.